Hello, and I appreciate y'all giving us some time to speak this afternoon. And like you can see, I'm not Randy Helton. I am Bryan Kinsey, and let me go ahead and correct that. If I hit the right button, it would have corrected. How do I advance this thing? Where do I point it? Because I'm hitting a green button. Yeah. That's the one I'm hitting. Oh, there we go. All right. Well, that was fun. Let me go ahead and tell y'all a little bit about myself. One is people tell me all the time I'm too serious. I look like I'm either angry or mad. I can assure you neither of those are true at this moment. And some people also say you're not funny when you think you are. So y'all will be the judge of that. But I will tell you, this almost feels like a little bit of a homecoming for me. I currently live in Wilson County, and I have lived in the Mount Juliet area for about 8 years now. But prior to that, I spent my first 42 years in Dyer County. Born in Dyersburg, raised in Dyer County, out and around New Bern and Trimble area. And I got reacquainted with Jane May from Dyer County, who many of y'all know, I'm sure. She worked in the school office where I went to school, kindergarten through 8th, Trimble Elementary. And Stephen Moppet and I were high school well, I shouldn't say pals. We barely knew each other in high school, but he's 2 years younger. We did graduate from the same high school, and we did know each other, and we have a lot of same friends. So it's good to get back and spend some time with some of these folks, and again, appreciate being here. So we are going to talk about the topic of Greenbelt. Not necessarily from a legal perspective, but just more the program, as a whole, what it is, and a little bit about, maybe help you understand it a little bit better. So, and I guess I'm going to try to not turn around and look at that a lot, because that's another thing I do that people don't like. I'll try to look down here. See, that was my attempt at being funny, and y'all didn't think it was funny at all. The Greenbelt Law was enacted in 1976, and it's more formally known as the Agricultural, Forest, and Open Space Land Act. The purpose of it is to preserve farmland and help protect farmland from encroaching cities that are spreading out, and putting pressure on the farmers, making it hard for them to compete. The land becomes more and more valuable, and they're having to buy it. You know the routine. So that was the purpose, is to help preserve that type of land. And the way it does it is it establishes, for property tax purposes, it establishes a value called the use value. We'll get into that here in just a minute. So use value is more of a how is it being used versus what would it actually be worth on the open market. So we'll go through the two value concepts here very quickly. Use value is developed statutorily. There's a formula in statute that tells us how to do it. And I guess I should have made it a little bit more clear. So I'm an assistant director with the Division of Property Assessments in the Comptroller's office, and the majority of our resources in any given year are dedicated towards supporting property assessors in the 95 counties. We do also work with collecting officials, trustees, county trustees, city collecting officials. Most of our resources are dedicated toward property assessors. Most of our staffing across the state are out there hand in hand with the assessors on an almost daily basis. So this is something we deal with. We work with the assessors on every year. Again, the statutory formula, it blends an income approach, and we won't go into the specifics about what an income and a market approach are, but just trust me, it blends an income approach with a market approach, weighting at 2/3 income, 1/3 market. And the statute also puts a 6% per year cap in place to prevent that value from going up more than 6% in any given year. Contrast that with market value. Market value is, if you think about an appraisal, you hire an appraiser to appraise your property, your land, your home, or whatever. What that appraiser is going to be doing is looking at comparable sales that occurred between willing buyers, willing sellers, what you call an arm's length transaction. There was no duress, no sort of court order to sell the property, anything like that. It's been on the market, so forth and so on. So those are the two types of values that we talk about when we talk about how we value agricultural land for property tax purposes. So we're going to show you an example of the use value. Again, I said we're not going to get into the specifics, but if our methodology said that this piece of property is worth $1,000 an acre based upon the income it can generate, but it's worth $4,000 an acre based upon what it would sell for in the open market, we then use a formula to weight it so that it's 2/3 income. You see it's 1,000 plus 1,000, so it's two parts of that three-part formula. And the third part is the market value, 4,000. You total those up, divide it by 3 to weight it out. You would see that the use value using this statutory formula is now $2,000 an acre, not $4,000, which is what the market would indicate it should be worth. Now, these are hypothetical numbers, but this is somewhat realistic. So you see there that word maybe. It calculates at $2,000, but it may not actually be assessed at $2,000 because of that 6% cap. Property assessors in this state can choose to reappraise their properties every 4 years, every 5 years, or every 6 years. We're assuming a 6-year reappraisal cycle here and saying that if the previous value had been $1,200 and it's only allowed to go up 6% a year for a 6-year cycle, that means that $1,200 can only go up 36% to $1,632, which would mean that even though statutorily the formula calculates out at $2,000, there's also the cap of $6,000 a year, which limits us to $1,632 for assessment purposes. There are 3 types of greenbelt property. The one that's most common to everyone in here and really most common across the state is agriculture. The second most common is forest, and the third, and far and away the least common, is open space. For land to qualify as agricultural, it needs to be 15 or more acres, and that includes any woods or wasteland that may be included on that tract. And it either needs to be actively engaged in farming, or there is what's called a family farm provision that might qualify a farm that's no longer actively engaged in agriculture, but it still can qualify through a family farm provision. So what does an engaged farm unit look like? It's, as we would imagine, it's a piece of land that's engaged in the production or growing of agricultural products. And it's not just sitting there that could be used, it's actually being used agriculturally. So some common farming activities. That looks like me as a kid. I was going to tell y'all, when I started my origin story a minute ago and I lost my train of thought. I've 8 years in Middle Tennessee, and before that 42 years in West Tennessee. I remember my first love, and I bet a lot of you have this in common with me. My first love was a John Deere 4020, and that's not a John Deere 4020, and I think you all know that. But I remember as a little kid, loving to sit in somebody's lap and drive that John Deere 4020. I wish I could drive one today. I mean, I see them occasionally at like an antique tractor, something like that, but I love that tractor. But as I got a little older, we had an International Harvester 686. We were really small farmers, 45 acres, hobby farm, no big deal, but I did grow up on a farm and I wouldn't trade it for the world. But I remember trying to get the front wheels off of that, up in the air on that tractor all the time. And if we had something heavy enough back on that 3-point hitch, you could pop a wheelie. And that's up. But that alone is not agricultural activity. It's fun for kids whose dads aren't watching them like they should when they're out there on that tractor. But a lot of you can probably identify with that. I'm sure a lot of us grew up in similar ways. So common farming activities, of course, are crops and things like plants. These are some things we might not think about as much. Animals, of course, we all know that. And then some that are even a little less common, but still qualify in Tennessee as agricultural use. Aquaculture, a nursery that's growing plants, or floral products, things like that. So, and this is not an inclusive list. There may be other things. So there's no standard that you have to be doing a certain amount of farming to qualify, but there is what we call an agricultural income presumption. In the law, it talks about a $1,500 per year income that a farmer should be generating off a property in order for it to qualify as agricultural. This final bullet point there is kind of a fancy term that if you're in the legal world at all, you probably understand that without explanation. I literally had to Google it to make sure I understood how to explain it. But the presumption is rebuttable. It's basically saying that it's kind of like this, you're presumed innocent until proven guilty type thing. You don't have to prove you make $1,500 a year, is basically what that means. It's going to be assumed if you say it's so, then the assessor will generally agree. The family farm provision, I mentioned that a few minutes ago. This is one of those cases where if it's at least 15 acres, it's been farmed by either the owner or the owner's parents, so forth, for 25 years, and the current owner still lives, the residents on that property, even if it's not still used for agriculture, as long as it's not an inconsistent use, it hasn't become an amusement park or something, then it can still qualify as agricultural land for assessment purposes. So, I brought a bottle of water up here with me, and there's 2 other bottles of water up here on this podium, so I've done messed up. I don't know. I have to figure out which one's been drank out of. I think it's this one. Thank you. Okay, so forest land. Like agriculture, it needs to be 15 acres or more to qualify. That wasn't always the case. That became true in 2017. Prior to that, I think as little as 3 acres. I forget exactly, but that was amended in 2017. It needs to be managed as a farm, as an agriculture, listen to me. It needs to be managed as a forest. There needs to be some evidence that it's managed as a forest, and I think maybe the next slide talks about that a little bit. Tree growth needs to be sufficient to justify it being classified as a forest. The assessor's office that administers this program in every county is going to want to see a forest management plan for any tract that a landowner is trying to qualify as forest. Our State Board of Equalization has an approved template for a forest management plan. Any type of management plan will work. That one's not required. It's just out there for people to see as an example. So y'all know I didn't produce this presentation, just for the record. So a younger guy than me did, and he thought this slide was cool, so let's just run with it. He says, what if the assessor's not sure? Is it forest or is it just some random trees? Well, they can consult by statute. The state forester, if requested by the assessor, shall provide that support to the assessors of property. So, and the third least common that I mentioned was open space. It's not as simple as just being open land. We'll get into that just a little bit here, but it's 3 or more acres. Characterized by an open or natural condition, provide some public benefit that are described in statute. And the important one is it must be designated by some sort of planning commission that designates it as such. So the legal reference here, Tennessee Code 675-1002, 2A through E, describes a little bit more about open space. If any of you want to jot that down, I'm sure you're going to want to read about that tonight. It talks about the types of things that qualify a property for open space classification, the use, enjoyment of and economic value of surrounding residential. That's boring when I read it. I bet it's boring to you when you hear it, isn't it? The conservation of natural resources, water, air, and wildlife, the planting and preservation of land in an open condition, and so forth and so on. It's not really common. That's why I can't just rattle this off the top of my head. I'm having to read that slide word for word. It's not something we see a lot of across the state, but a little bit of it does exist here and there. Oh, I'm sure some of you are golfers. You might think, well, a golf course, that kind of fits all those descriptions. It's for public use and it's wide open and all that type of thing, but no. Golf courses are not open space. So, the title of this slide is called HOMESITES. That's kind of an assessment-specific type term. Sometimes it might be called improvement site. But basically what that means is, imagine you've got a 100-acre farm with a house. Well, that acre, give or take, it could be more, it could be less, but generally roughly about an acre is what we allocate for assessment purposes. That's what we call the home site. And that home site is not valued at use value. That home site is valued at market value, just like any other approximately 1 acre residential tract would be. So we're going to talk just, the concept of a home site applies whether it's agricultural, forest, or open space. I kind of already touched on this a little bit. It's assessed at market value, generally for assessment purposes, without any evidence to the contrary. The assessor's office generally presume a 1 acre home site. If it's a really elaborate, huge piece of land that's taken out of the farm and it's all manicured lawn, they might go ahead and measure it out as a 2 or 3 acre home site, but typically an acre and so forth. So, I mean, you can't just say, hey, I want to be in Greenbelt. There is an application process. It is class specific, so there's one for agriculture, there's one for forest, there's one for open space. There's a March 1 deadline each year to sign up for Greenbelt. It has to be approved by the assessor's office. It has to be recorded with the Register of Deeds. And you have to pay as a property owner, you got to pay any necessary fees. I mean, at a minimum, you're going to be paying that recording fee to get this document recorded. There is a statutory provision where you can bring in one after March 1, a late application, and there's a $50 additional fee if you bring it in late. But generally, there's a process in place. It's been working for many years, and it's pretty well established and not a whole lot of question about how the application process works around the state. So we've discussed the fact for the past few minutes that Greenbelt establishes a use value which is lower than market value. So that means you're paying taxes on something less than market value. So what that means is there could be a situation where if you change the use of your property, and we'll get into a couple of examples of that, but you may be subject to rollback. And the rollback basically is a recapturing of the savings that you've enjoyed for the past 3 years. It's not a penalty. It's nothing more than paying back what you saved over the past 3 years, because by signing up for Greenbelt, you kind of sort of committed you're going to keep it in agricultural use, and then when you change that use, you pay back some of that savings. Nothing additional, no interest, no penalties, anything like that. Like I just said, it's a 3-year rollback on agriculture and forest. It's a 5-year rollback on open space. And it's a 10-year rollback on a really unique situation called an open space easement. Apparently there is a penalty involved with that one, so I misspoke when I said there's no penalty. This slide here says there's a 10% penalty for the identified development area. So again, I told you a few minutes ago, open space is one of those things we don't deal with a lot, so it's kind of easy for me to lose forget that I don't know everything about open space off the top of my head. So what are some circumstances that may trigger rollback? The land no longer qualifies due to some change you've made to it, or maybe the owner I don't know why you would do this, but in some instances, an owner might come to the assessor and hand them a written request that says, I no longer want to be in Greenbelt. Or you decide to develop this property and you record a subdivision plat that says, I'm going to subdivide this and sell off 50 1-acre lots. Well, when you sell that first lot, you record it and sell that first lot, the whole thing comes out of Greenbelt because now you've developed it, you've started the development process. Let's see, some other examples. A new owner fails to file an application. So, you sell your property, the new owner says, oh yeah, I'm going to keep it in Greenbelt, but that new owner fails to come in and qualify. There could be a rollback. And that can get tricky because that rollback can actually be to you as the one who sold it. Even though you didn't change the use, you indirectly changed the use by selling it to someone who didn't maintain agricultural use of it. That becomes a matter between the seller and the buyer. Usually that kind of thing is worked out at closing in the real estate transfer. Or if you own more than 1,500 acres and maybe accidentally some of it got qualified at one point in time and some of it had to be taken out, but that's a pretty rare situation. Or the land is sold and becomes exempt, and that's basically changing use. If you sell some property and you weren't If you sell it through eminent domain, where a state agency, or I'm not a state, but a governmental agency basically uses the power of eminent domain to force you to sell it, you're not going to be liable for rollback there. But you sell it to a church or whatever, anything that's exempt, there's going to be rollback there. Okay. I don't know about y'all. I've spent, well, probably none of y'all have spent 28 years working in property tax like I have. But I was going to say, I don't know about y'all, but in my opinion, it's probably a little biased, but I feel like property tax is probably one of the most fair taxes we have in this country. And the reason I say that, you know, David talked about sales tax a little bit. You go to the grocery store and buy a loaf of bread and go up to that cashier, you're not going to have any say-so in how much sales tax you pay for that loaf of bread. You know, it's going to be whatever it is, and it's not negotiable at that point in time. But with your property taxes, every one of you that own property actually have a right to appeal that property. So you do have a voice in your ultimate tax bill, not only through who you elect to represent you at the county or city level that are setting the tax rates, but you also have a voice because if you feel that you feel it's unfair, you have the right to appeal it. It's a little different with agricultural, with greenbelt properties, and we'll talk about the differences there. So, but for ag properties, or for greenbelt properties, for greenbelt properties, you can appeal the market value of that property, or you can appeal the fact that the assessor denied you the greenbelt classification. You can appeal the use value, sort of. We'll get into that here in just a second. And you can appeal whether rollback taxes were justly assessed to you. So your first kind of formal level of appeal, you can always talk to the property assessor in an informal manner, and maybe you can come to some sort of terms, some sort of agreement. But the first sort of formal level of an appeal is at a county board of equalization. I wouldn't be surprised if there's somebody in this room that has served on a county board of equalization. Any of you know what I'm talking about at the county level? Yeah, I see at least one hand go up. Yeah, two hands. Yeah. So that's the first formal level of appeal, the county board of equalization. You can also, what was that previous slide? I think that was market value, wasn't it? Anyway, you can appeal the application if it wasn't timely filed. You can take that to the county board or the state board of equalization. Use value is where it gets a little weird because, like we said, market value is one thing, use value is another. Use value is established in statute by a formula. You, as an individual property owner, can't go to your property assessor and appeal your use value because it's set forth in statute. The assessor didn't set that value. But what can happen is a group of 10 or more property owners or an organization representing 10 or more property owners has the legal right to appeal use value in a county. They must do so by filing with the State Board of Equalization, and they must do it on or before 20 days after the date the Division of Property Assessment, that's who I work with, we publish notice of the use value schedule. So every county that goes through a revaluation by statute, we put a notice in papers of general circulation in that jurisdiction saying use value has been recalculated and the records are available for your inspection. Here's your right to appeal, but you got to do it within 20 days. So there are ways to appeal use value, but it's not quite as simple as appealing market value. Again, you can appeal rollback taxes to the State Board of Equalization. The appeal must be made by March 1 of the year following the date the assessor sends notice that the property has been disqualified and rollback taxes are due. So there is a time element there in order to appeal rollback taxes. So I'm getting near the end here. These are some of the resources that you have at your disposal if you want to learn more or be more involved in any way whatsoever with Greenbelt assessments. Your local assessor of property is very knowledgeable. We just had elections of assessors, and we're going to be having 11 new property assessors out of the 95 counties that will be sworn in September. It'll be my office's job to help provide them some training and orientation. We look forward to getting to know them. The Division of Property Assessments, we're available to you as a resource. law, Tennessee Code Annotated. We have a Greenbelt handbook, and of course Farm Bureau actually has some literature about Greenbelt. This is a cover page of our handbook that is updated pretty regularly. I think that date shows, yeah, we updated as recently as July of this year. It's on the Comptroller's website. I don't know how well you can see that, but that's, if you go to the Comptroller's website and then navigate to office functions, property assessments, that's actually a screenshot of a lot of our staff at a meeting back when life was normal. You remember how we all used to crowd into rooms like that and not wear masks like we're all doing now? Farm Bureau has Greenbelt literature. And I failed to mention earlier, we've enjoyed a great relationship the Comptroller's office has with Farm Bureau for many years. I've only had the privilege of working in the Nashville office. You know, kind of said a couple times, I've lived in this area for about 8 years. So I came to Nashville 8 years ago. Prior to that, I was in our field office in Jackson. But in my 8 years, I've had the pleasure of working fairly often with people like Stephan, and some people before me worked more closely with Radonna. But I don't know that we've always seen eye to eye on every issue, but we've always had a great collaborative spirit and been able to work together and share information, and we've had a good relationship with Farm Bureau over the years. We appreciate that. So I know we'd save some time for questions at the end. Again, my Randy that prepared this presentation was afraid nobody would have questions, so he threw a couple of FAQs in here. It's just a couple of them. We can either hit them or we can just wait and see if you have actual questions.
I've got some questions.
Okay.
Okay, first question is, if an owner builds a home for himself on a Greenbelt farm, is he charged the rollback taxes on the home site?
Well, if the home site was previously engaged in agriculture, if the homeowner took an acre of soybean cropland and then made it a residential lot and built a house, there would be rollback tax on it.
Okay. And also, if the real estate contract states that the buyer is responsible for re-enrolling in Greenbelt and he does not reapply, will the new owner be responsible for rollback, or the seller who received the benefit of the lower taxes?
Wow, that's an excellent question, because I was afraid somebody might ask a question like that. It can get really tricky, it can get really messy, and I did say that generally in a real estate closing, those types of things are considered. The way I understand, and I'm not an attorney, after I graduated college, most of my on-the-job training has been in appraisal. So, but I'm not an attorney, but it's my understanding that the onus, so to speak, or literally to say the burden is on the seller when it comes to rollback taxes. But that burden, that onus can be transferred to the buyer through a contract at closing. What happens if that buyer doesn't honor that contract becomes another matter that I'm not sure I could speak to that. But it can get messy. It's best if you are buying or selling land that's in the Greenbelt program that you really understand what you're buying or selling and know what your risk may be.
Okay. Since you referenced duress sales, the Greenbelt formula includes a value for average farm-to-farm sales. We have often heard that the farms sold by auction are not included in the farm-to-farm sales data, even if a farmer purchases the land, because auctions are considered duress sales. A lot of farmland sold outside of the family is sold by auction. What are your thoughts about not considering auction sales?
Man, y'all are good. Some of y'all know how to ask the hard questions, don't you? That concept right there is something we debate in the assessment industry, actually. And a lot of us are members of and subscribe to a lot of standards that are published by the International Association of Assessing Officers. And they've got all kinds of stuff written about auctions. But I can tell you the official position is that a well-attended auction with competitive bidding going on, where there's no reason to believe that anything unusual was occurring, generally those sales could be considered arm's length transactions. But I will tell you there's always a cloud over an auction sale in our minds in the appraisal or assessment industry. There's some doubt when you encounter an auction sale. You know, we much would rather rely on sales that occurred through traditional means. And of course the most traditional, and I don't honestly know how often this happens with farm sales, but the most traditional means is you list it with a real estate agent that's exposed to the market. People have time to inspect it and think about it, and but it's one of the answer to this question is it really depends. The assessor's offices are required to, by statute, maintain what's called a sound program of sales verification. And what that means is, and some of you that have bought or sold property may have experienced this in your life with your local property assessor. What the assessors are required by law to do is investigate to some extent any sale that occurs specifically with farm sales and specifically with commercial or industrial sales. They're also required to verify residential sales, but not to the same extent. So they're generally going to investigate, by law, they're going to investigate every farm sale and make some determination of those circumstances. I would say more often than not, though, if you said, just give us an answer, I'd say more often than not, auction sales are not included when we're doing market analysis.
Okay. We got one more tough one. We're going to let you off the hook.
Okay.
How much and how soon do you expect Greenbelt evaluations to decrease since commodity prices have fallen over 65% in the past few years? Our county claimed high grain prices were the reason for the past increases. So now that they have gone down severely, does that not make sense that they should decrease?
Remind me not to agree to this again, will you? Okay. So it looks like I should have gone into the calculation of the income value a little bit more, because that's really what that is about. So the income value is established using, I believe it's a 5-year average of commodity prices. So the way you develop an income value, if somebody says, well, give me a quick explanation of an income value, it's what income will it generate divided by what's called a cap rate or a capitalization rate. So if you take an income, divide it by a cap rate, you can get a value. So those are the two basic variables in an income approach. The income part of our income approach comes from a 5-year average of commodity prices. And I honestly forget what our source is of that, but it's maybe Tennessee. Who would it be, Stephan? Is it University of Tennessee? I forget who publishes that. What? Farm Credit? The commodity prices, the yields and prices. Yes, that's who it is. Yeah. It's been a while since I've done that. But yeah, so we're using published data to develop the income, the commodity prices, and the commodity yields. So that's one part of the equation, and the other is that cap rate, which I forget the source of that too. I should have been. That's the Farm Credit one. So all of these are published. It's all published data. We're just kind of doing the mathematics on it. But okay, I lost my train of thought there for a second. The income value, again, is 2/3 of the use value. It's 2/3 of that formula. So, yeah, I guess it is conceivable. It just depends on how it all comes out in the wash. The income part, if commodity, was it prices that were down in this question? If prices are down but yields remain about constant or maybe have gone up a little bit, then you've got some math that's going on there. And then you've got, where's the cap rate going? That's part of it. And then this other part of the whole Greenbelt value is the market. So that's 1/3 of that formula. So you could conceivably have lower commodity prices, but all those other things offset that, which end up with a value that's higher in the end, because it's not just about commodity prices.